Good morning, everyone, and welcome to the first part of our two-part webinar series discussing significant and construction and adjudication cases of 2024. These webinars aim to cover key developments in construction and adjudication practice during 2024 and how these might affect your construction project disputes in 2025. The webinar today will focus on our chosen top 5 construction cases of 2024. We will highlight the main facts and legal points of each and identify specific lessons to be aware of for construction contracts and claims. Our next webinar, focusing on our chosen top 5 adjudication cases of 2024, takes place on the 6th of March 2025. If you'd like to ask a question during this webinar, please do so by using the question and answer button. In order to keep within the time, we'll be answering as many questions as we can at the end of the presentation rather than as we go along. And if we don't manage to get to your question, or if you're listening to the recording of this webinar, we'd be more than happy to address any queries you have by webinar, about the webinar by phone or email. Our contact details are noted on the next slide. So I am Shona. I'm a solicitor specialising in property and infrastructure disputes, and I'm joined by my colleague Igor, who's a senior solicitor in my team. Our team regularly advises on property and construction issues and disputes across a range of projects and industries. Igor and I will be organising Shepherd and Wedderburn's construction and infrastructure seminars throughout 2025, so please keep an eye out for all of the exciting sessions that we have planned. So now on to the agenda for today's seminar. The first case we're going to be discussing is Abbey Healthcare Mill Hill Limited against Augusta 2008 LLP, which is also known as Simply Construct UK LLP, which looked at whether collateral warranties were construction contracts. We'll then consider conditions precedent in the Scottish case of FES Limited against HFD Construction Group Limited. Our third case is Tata Consultancy Services against Disclosure and Borrowing Service, which concerns statutory interest rates. Our fourth case for discussion is the Secretary for Levelling Up and Communities against Gray, which is about remediation orders. And finally, we'll finish up by considering the Scottish case of Leonardo Hotel Management UK Limited against Galliford Tribe Building 2014 Limited, and another, which is about prescription and limitation. It's worth noting that in the time available, we will be taking you through these cases pretty quickly, and the focus will be therefore on the key points which we think are most relevant to you and your practice. However, please be aware that there may be other important points coming out of these cases that we will not cover today. So without further ado, I'm going to pass over to Igor to take us through our first two cases.
Thank you very much, Shona. So our first case is Abbey Healthcare against Simply Construct UK. In terms of background to the case, it concerned a dispute over fire safety defects at a care home in Mill Hill in London. The claimant, Abbey Healthcare, as tenant, was the beneficiary of a collateral warranty provided by Simply Construct. The dispute between the parties arose in 2018, following which remedial works began in 2019 and completed in 2020. Thereafter, in 2020, Simply provided a collateral warranty, warranting that it has performed and will continue to perform diligently its obligations under the building contract. Following this, Abbey referred a claim against Simply relating to the defects to adjudication, which was decided in Abbey's favour. Simply unsuccessfully argued that the adjudicator could not decide the dispute and later resisted enforcement of the decision. In relation to the legal issue in this case, the central question was whether the collateral warranty constituted a construction contract as defined by the Housing Grants Construction and Regeneration Act 1996. This determination directly impacts the applicability of the Act's adjudication provisions. Simply argued that the warranty did not meet the criteria of a construction contract. The adjudication provisions of the Act did not apply, and this rendered the adjudicator's decision unenforceable. And the case was heard in the Technology and Construction Court, which ruled that the collateral warranty was not a construction contract. And this decision was thereafter overturned by the Court of Appeal, which held that the warranty did qualify as a construction contract, and Simply then appealed to the Supreme Court. And the Supreme Court overturned the Court of Appeal's decision, ruling that the collateral warranty was not a construction contract under the Act. Lord Hamblin clarified that a collateral warranty generally provides a right of action concerning defective works rather than the carrying out of such works. Lord Hamblin stated that if a collateral warranty merely promises that the construction operations under the building contract will be undertaken, then it is the building contract that gives rise to the carrying out of the construction operations, not the collateral warranty. A collateral warranty will only be a construction contract under the Act if the warranty undertakes to provide construction operations for the beneficiary which are not merely derivative and reflective of obligations owed under the building contract. So in terms of key takeaways from this case, the Supreme Court judgment distinguished between different types of collateral warranties. On one hand, those warranties that merely replicate obligations from the building contract are not construction contracts under the Act. And another point is that those warranties that involve separate or distinct obligations for construction operations for the beneficiary are considered construction contracts under the Act. So in terms of implications and conclusions on this case, we think that the ruling clarifies that adjudication will not be automatically available for resolving disputes under collateral warranties. The decision also ensures that the Construction Act applies to the actual carrying out of construction operations rather than simply providing recourse for defects. And finally, the Supreme Court prioritized certainty, drawing a clear line between warranties that merely restate obligations from the building contract and those that introduce separate obligations. And so now on to the next case, which is a Scottish case of FES Limited against HFD Construction Group Limited. And the case concerns a 2020 construction contract for the fit out of commercial premises in Glasgow. And the contract was an amended version of the SBCC standard building contract with quantities incorporating JCT conditions. And clause 4.20.1 provided that the contractor, FES, could claim for loss and expense arising from delays subject to compliance with clause 4.21. And clause 4.21 mandated that FES provide notification to the architect or contract administrator regarding potential loss and expense, including an initial assessment and supporting documentation. The project experienced delays, including those due to the COVID-19 pandemic. FES initiated adjudication in 2022, claiming an extension of time and loss and expense. And the legal issue in this case was whether the notice provisions in clause 4.21 of the contract constituted a condition precedent to FES's entitlement to claim for loss and expense under clause 4.20.1. The core question was whether FES's failure to comply with the notice provisions in clause 4.21 invalidated their claim. The adjudicator initially held that the notice requirement under clause 4.21.1 was a condition precedent to any claim under clause 4.20.1. And as FES had not met this requirement, their claim was dismissed. And the decision was thereafter upheld by a commercial judge in the Commercial Court of the Court of Session, Lord Richardson. FES then appealed to the Inner House of the Court of Session, arguing that first, the commercial judge had not properly considered the commercial context of the contract. Second, the contract did not explicitly state that the notice provisions were a condition precedent. And third, JCT guidelines did not suggest that clause 4.21 should be interpreted as a condition precedent. FES argued that the outcome was commercially unreasonable because failure to comply with the notice requirements should not result in the total loss of entitlement to recover costs. And the Inner House dismissed the appeal, affirming the decision of the commercial judge and of the adjudicator. The court emphasized the unambiguous language of the contract, stating that the phrase subject to compliance with the provisions of clause 4.21, clearly made any entitlement to claim under clause 4.20.1 conditional upon compliance with the notice provisions in clause 4.21. The court held that FES's interpretation would necessitate ignoring this explicit wording of the contract. Furthermore, the court held that in the absence of ambiguity, external factors such as commercial common sense were not relevant, and that the need to be duly notified of potential liability was commercially reasonable. In terms of key takeaways from this case, notification requirements in construction contracts are likely to be interpreted as conditions precedent if the contractual language suggests this, irrespective of whether the term condition precedent is explicitly used. Courts will strictly interpret contractual language and will not resort to external factors such as commercial common sense when the contractual terms are unambiguous, as it was in this case. It is critical that contractors adhere to all notice provisions in their contracts to preserve their entitlement to claim for loss and expense. Contract administrators and architects must ensure that these provisions are properly implemented. And finally, failure to comply with notice provisions may result in a complete inability to recover legitimate costs and loss. We think that this case serves as a reminder of the importance of compliance with contractual obligations and adherence to notice provisions in construction contracts. The decision reinforces the principle that courts will uphold the plain meaning of contractual language, and that contractors must be aware of the potential ramifications of not fulfilling all contractual obligations. The decision has significant implications for the management of construction contracts, highlighting the need for strict contractual administration by both contractors and contract administrators, and careful drafting of notice provisions as well. And I'll now hand over to Shona.
Thanks very much, Igor. So our third case today is a case against the Technology and Construction Court, which is Tata Consultancy Services against Disclosure and Barring Services. This case clarified how parties can disapply the statutory right to interest in late payments under the Late Payment of Commercial Debts Interest Act 1998, which I'm going to refer to as the Late Payments Act. The court held that applying interest to undisputed debts, but not to disputed debts, was sufficient to oust the Late Payments Act. Before we turn to the content of the case, I think it's worth summarising what the Late Payments Act says. It provides a statutory right to claim interest on late payments in commercial contracts. This remedy applies to late payment of qualifying debts, and qualifying debts are debts connected to obligations to pay the contract price, including interim payments under construction contracts. The rate of interest under the Late Payments Act is currently set at 8% above the Bank of England base rate, which I think is currently 4.75%, so a total of 12.75%. Contract provisions attempt to exclude the statutory right to claim interest under the Late Payments Act are void unless the contract provides a substantial alternative remedy for late payment. According to Section 9(1) of the Late Payments Act, a contractual right to interest is considered a substantial remedy unless one of two things applies. So the first is that that remedy is insufficient to compensate the supplier to deter late payments, and it would not be fair and reasonable to provide the remedy as an alternative or variation to the statutory right to claim interest. So in Tata Consultancy Services Limited against Disclosure and Barring Services, an outsourcing and software development contract provided that interest on undisputed invoices or parts thereof was to be paid in accordance with the Late Payments Act. However, no interest rate was stipulated for late payments of disputed amounts. Instead, these were to be subject to a dispute resolution process. The court held that there was no obligation to pay a disputed sum. There was no obligation to pay a disputed sum which could arise until that dispute had been resolved. So disputed debts would not actually count as qualifying debts for the purpose of the Late Payments Act. It didn't come into play at all. However, what the court did do, helpfully, was go on to explain that a remedy which seeks to distinguish between sums which are disputed and those which are undisputed is nevertheless a substantial remedy under the Late Payments Act. So the court considered that the distinction between disputed and undisputed debts mirrored the policy of the Late Payments Act and the differences in principle discussed in earlier case law. So the court cited the earlier case of Banham Marshall Services Unlimited against Lincolnshire County Council, in which it was observed that the mischief to which the statute appears to be primarily directed is that of causal or feckless non-payment. So in other words, the statutory interest under the Late Payments Act was intended to penalise late payment without good reason. The Act's provisions were not intended to deter legitimate payment disputes over liability for a debt or the amount to be paid. In light of this, the court found that the lack of interest in disputed debts was fair and reasonable. This means that Section 9(1)(b) of the Late Payments Act was not triggered, so the contractual right to interest remained a substantial remedy. Further factors that supported this conclusion included that the parties had relatively equal bargaining power, and they also had a highly specific and detailed contract. So what are the key takeaways from this decision? I think there's probably two main ones. The first is that it can be fair and reasonable to exclude the Late Payments Act application for disputed debts. And secondly, whether the Late Payments Act can be disapplied will be impacted by factors such as the parties' bargaining power and how detailed your contracts are. I'll now pass back to Igor for our fourth case.
Thanks, Shona. And the next case is Secretary for Levelling Up and Communities against Gray. And this is a case that relates to the legacy of the Grenfell tragedy, as well as the Building Safety Act 2022. So as we all know, the Grenfell Tower tragedy exposed failures in building safety, which catalyzed the enactment of the Building Safety Act 2022. The Act fundamentally shifts the landscape, ensuring residents are not burdened with the costs of remediating safety defects. The key to the Act are remediation orders, ROs, that could be made under Section 123 of the Act, empowering the English First Tier Tribunal to compel landlords to rectify relevant defects in relevant buildings, and both terms are defined. A relevant building is defined as a self-contained structure in England containing at least 2 dwellings and standing at least 11 meters high or having 5 or more stories. A relevant defect is broadly defined as an issue arising from works within the past 30 years that present a building safety risk. And the Act's core principle is the prioritization of leaseholder safety and financial protection. So the case of Gray revolved around Vista Tower, which is a 16-story building in Stevenage, converted from offices to flats in 2015 by Edgewater. Gray, acting for the Railpen Pension Fund, acquired the freehold in 2018. And early 2019, Stevenage Borough Council identified the presence of combustible panels within the building, but an initial inspection indicated no immediate action was required. The Building Safety Fund, BSF, was introduced in 2020, and in 2021, Gray applied for funding for remedial works. By January 2022, government guidance on cladding defects changed with the introduction of the PAS 9980 framework. Thereafter, in November 2022, DLGHC applied for remediation order. Remediation works finally began in January of 2024, and the remediation order was granted in April 2024. So the timeline really illustrates the protracted nature of the remediation process, the involvement of multiple stakeholders, and ultimately the government's intervention using their legislative powers. And so in terms of the First Tier Tribunal's approach to the case, the tribunal acknowledged the delays but refrained from assigning blame, focusing instead on ensuring that the defects were remedied efficiently. The tribunal also noted that its jurisdiction should be practically focused on ensuring the defects are remedied, agreeing that the Building Safety Act's primary focus is the protection of leaseholders. Despite Gray's demonstrated efforts towards remediation, the FTT issued a remediation order as a backstop for leaseholders, as they were not party to the construction contracts. The support of 57 leaseholders significantly influenced the decision as well. The order was explicitly made subject to the existing building contract and funding agreement, showing a practical approach of the tribunal. And in terms of key takeaways and implications for the industry, the case highlighted that the government is prepared to use the Building Safety Act to enforce remediation works. The FTT is prepared to issue remediation orders even when remedial works have already commenced, as it was in this case. The ruling highlights that leaseholder protection is paramount under the Act. The tribunal acknowledged the financial realities, noting that it was impractical and unreasonable to expect Gray to forward fund the works, given the size of its pension fund portfolio and the associated costs. The FTT adopted a pragmatic approach, integrating existing contracts and funding agreements when issuing orders. And so in terms of key implications, we think the case highlights increased scrutiny of landlords and their remediation plans, a greater legal certainty for leaseholders, a clearer precedent for future remediation cases, and the need for robust contract and funding strategies for landlords. The case represents a crucial point in the application of Section 123 of the Building Safety Act 2022. It highlights the necessity of timely engagement and effective remediation of building safety defects. It underscores the importance of proactive steps in ensuring compliance. The decision demonstrates the court's commitment to using all powers under the Act to protect leaseholders and to make sure they are not burdened by cost of the remediation works. And I'll pass back over to Shona now.
Thanks very much, Igor. So our final case today is one decided in the Outer House of the Court of Session in Scotland. The case concerned defective cladding, collateral warranties, and the issue of prescription under the Prescription and Limitation Scotland Act 1973. Prescription is a doctrine which time limits when certain claims can be raised in court, and the case provides clarity as to the time limits which apply. So the case is Leonardo Hotel Management UK Limited against Galliford Try Building 2014 Limited and another. So what are the facts of this case? The case concerned alleged defective cladding at the Leonardo Inn Hotel in Union Square in Aberdeen. Galliford Try were the design and build contractors, and the other party, Building Design Partnership Limited, was the architect. Both were employed by the owner or landlord of the property. It's helpful to have a brief timeline for this case. So in terms of a timeline, in July 2008, both Galliford Try and the architect granted collateral warranties in favour of the procurer. The project was completed in 2009 and a practical completion certificate was certified on the 18th of February 2009. Also in 2009, the pursuer, Leonardo, entered into a lease with the employer landlord, and this was on the 8th of December 2009. Under the lease, Leonardo had to maintain the property free of defects. Following Grenfell, the employer or landlord surveyed the hotel's cladding on the 18th of September 2017, and the findings were reported to Leonardo on the 16th of September 2020. In February 2021, Leonardo raised an action against Galliford Try and the architect, claiming that the hotel's cladding system was defective and seeking the costs of repair. So the legal issue in this case was whether the case had actually been raised in time or whether it was time barred. The defenders argued that the case was time barred, or in other words, had prescribed. In short, they said that the claim arose from a breach of collateral warranty, and these claims must be brought within 5 years of the loss. They argued that the loss occurred when Leonardo entered into the lease in 2009, as it contained the obligation to keep the building free of defects. The cladding was already defective at that time, therefore the claim, they argued, had to have been brought by 2014, and raising the claim 12 years later was just too late. The court agreed with the defenders that on its face, the case had prescribed. However, it allowed the pursuer to prove that one of the saving provisions in the 1973 Act applied. These saving provisions are, first of all, under Section 11, subsection 3, that the pursuers were not aware or could not have reasonably been aware of the defects, and therefore that they'd suffered a loss. The second one's found in section 6, subsection 4, and that's that the defenders induced the pursuers to believe that there were no defects through their words or conduct. The court held that Leonardo had proved both of the saving provisions could apply, and therefore the case had not prescribed. First, the pursuer would need to know that they had suffered a loss, either actually or constructively. They'd need to know that the property was defective when they entered the lease with repairing obligations, but they did not. They only knew about the loss when they received the report in September 2020. Secondly, the collateral warranties that had been granted by Leonardo and the architect, by Galliford Try rather and the architect, contained statements suggesting that the buildings were defect-free. The court held that the pursuer was entitled to rely on these warranties and the statements, provided before completion that both the work they'd done so far and the work that the parties were going to do would be free of defects. The case proceeded to proof to hear evidence on whether these facts had actually been established. In other words, whether the statements that the work was free from defects had actually been relied on, and whether they did have any knowledge of the loss that occurred. But the key takeaways from this one are that the case provides guidance on when these saving provisions will apply to collateral warranties. So factors such as the knowledge and providing statements and assurances within your collateral warranties may actually be relevant to delaying when the time bar period concludes. However, I would flag that new legislation came into effect on the 1st of June 2022. So we do now have a situation where there are two legislative schemes in place. So whilst a lot of the cases will be decided under the new scheme, some cases, such as this one, will still have the old law continuing to apply. So it's definitely something to be aware of. And now I'm going to pass back to Igor, who will take us through our key takeaways and bring us to a close.
Thank you. So yeah, in terms of lessons learned from all of the cases, we saw that first, collateral warranties replicating building contract obligations are not construction contracts, while those with distinct obligations are. If there's no ambiguity, external factors such as commercial common sense will not be relevant when interpreting a construction contract. Disputed debts can be excluded from the statutory right to interest on late payments. The Building Safety Act 2022 is a powerful tool to enforce leaseholder protection. And finally, Leonardo case, assurances given in collateral warranties may delay the start of the prescriptive period. We have now come to the end of today's seminar. We hope that this has been an informative look at some of the most important construction cases decided in 2024. We still have a few minutes to answer any questions. If you have not already done so, please type your question in a chat box now. And while you do that, I'd just like to remind that this webinar has been recorded and will be available on YouTube. So if you know any colleagues who haven't been able to participate today, or if you think this will be useful for anyone, then please let them know, and we'll be circulating details of the recording to participants after the webinar. So it seems that we do have one question which we have time to cover today. And the question is, what is considered a substantial remedy that is capable of disapplying the late payment of Commercial Debts Interest Act 1998, which was discussed in our third case. Shona discussed it, the Tata Consultancy case. And it's a good question, and there's no clear answer. However, another case from last year, which was A&B Building Solutions Limited against J&B Hopkins Limited, held that an interest rate of 2% above base rate was not a substantial remedy and did not disapply the 5% rate provided for in the Act. However, the court held it was always a matter of considering the fairness and reasonableness on the facts of each case. So factors like inequality of bargaining power were irrelevant in this case. I think our time up is for today, and if anyone has any further questions, please don't hesitate to get in touch with me or Shona. And thank you very much for joining us, and we hope you found the cases we discussed to be interesting and that you took something from our lessons learned as well. Please do keep an eye on the news and events section on our website for upcoming webinars or seminars and for our latest articles. And don't forget that the next of this two-part series will take place on the 6th of March, when we'll be looking at key adjudication cases from the last year. Thank you all very much.
Thank you very much, everyone.